Imagine it is 1905, and you are standing on the floor of a bustling Massachusetts manufacturing plant. The air is thick with smoke, and the deafening, rhythmic slamming of heavy metals surrounds you. You are working your 12th hour of the day, operating a massive industrial stamping machine. For a split second, exhaustion takes over. Your sleeve catches, and before you can even react, the merciless gears pull your arm directly into the press. In today's world, the next steps are obvious. You are rushed to the hospital, your medical bills are fully covered, and you receive disability compensation to keep your family afloat. It is a fundamental right. But back in 1905, the reality was brutally different. Instead of receiving financial help or medical care, you would be fired the very next morning simply because you could no longer work. You were left to foot the medical bills yourself and watch your family face absolute starvation. If you dared to sue your boss, the judge would likely look you in the eye and declare the accident your own fault. How did we go from a system where human life was cheaper than machine oil to the worker protections we take for granted today? To truly grasp the absolute insanity of this legal framework, we have to rewind the clock. We need to go back to an era before those massive black smokestacks blotted out the American sky. Before the 19th century industrial boom, the legal system handled workplace injuries through something called common law, a framework inherited directly from England. And to be fair, for a long time, this system actually made a lot of sense. Think about the American economy prior to the 1850s. The vast majority of the population was agrarian. People worked the land, tied to the predictable, slower rhythms of the seasons. Those who didn't farm usually worked in very small, local artisan workshops. You had a master craftsman, maybe a journeyman or two, and a couple of apprentices. If you were a blacksmith's apprentice, or a carpenter's helper, and you accidentally burned your hand on the forge or cut your leg with a handsaw, the dynamics of that accident were incredibly simple. The risk was obvious. The danger was entirely predictable. You could look at a piece of wood and a sharp blade and understand exactly what might happen. And most importantly, figuring out whose fault an accident was didn't require a team of expensive corporate lawyers. You either dropped the hot iron because you were careless, or the master accidentally knocked it into you. But beyond just assigning blame, the relationship between the employer and the employee in this era was deeply, undeniably personal. You weren't just a nameless employee identification number on a corporate payroll spreadsheet. You often lived in the master craftsman's house. You ate at his dinner table, you knew his family, and you worshipped at the exact same local church on Sundays. If that young blacksmith broke his leg and couldn't work for 2 months, the master craftsman would typically step in to help. He might provide some money, or at the very least, make sure the boy's family had enough firewood and flour to make it through the bitter winter. This wasn't because there was some sweeping federal regulation or labor board forcing his hand. It was driven by the immense moral pressure of a tight-knit community. If you were a master who let your injured apprentice starve to death in a town of 300 people, your reputation would be ruined overnight. If a dispute did get ugly, and you had to drag the issue into a local courtroom, a jury of your peers would simply use standard village common sense to decide who acted recklessly. Here is the part most people completely miss. That quaint, community-based legal system was utterly and entirely unprepared for the explosive arrival of the steam engine. Starting in the 1840s and roaring through the 1850s, America plunged headfirst into railroad fever and mass industrialization. Seemingly overnight, the very nature of human labor mutated. You were no longer working alongside 3 of your buddies in a well-lit, quiet wooden shed. You were uprooted from the farm and shoved into the belly of a mechanical beast. You suddenly became a faceless variable inside a colossal steel mill employing 3,000 people. The environment was deafening, suffocating, and terrifyingly fast. You were working under massive crucibles, holding tons of molten metal suspended by fraying ropes high above your head. Or perhaps you became a railway brakeman, tasked with the horrifying job of jumping between violently swaying train cars, trying to manually drop iron coupling pins while hurtling through pitch-black, freezing snow at midnight. The fundamental nature of workplace risk had completely shifted. It was no longer about accidentally hitting your thumb with a hammer. It was about sudden, explosive, catastrophic death. A bursting steam boiler didn't just injure a worker. It wiped out 20 men in a fraction of a second. A collapsed mine shaft buried fathers and sons alive in total darkness. As these grotesque accidents began to skyrocket at a scale the world had literally never seen before, the widows and orphaned children of these industrial workers started knocking on the doors of American courthouses. They were asking for basic justice. They demanded that these new, infinitely wealthy capitalist corporations take responsibility for the bloody carnage happening on their factory floors. The American legal system suddenly found itself standing at a terrifying crossroads. On one hand, judges could apply the old common-sense rules and force the burgeoning railroads and massive textile mills to pay for every severed limb and crushed skull. But there was a genuine, pervasive fear among the ruling class that doing so would financially bankrupt these infant industries. Railroads and steel were the economic backbone of a rising empire. To slow them down was viewed as standing in the way of national progress. On the other hand, they could protect the flow of capital, but it would require intentionally sacrificing the lives and livelihoods of the working class. Faced with the choice between protecting human life and protecting investment capital, the judges of that era made a decision that would brutally define American labor for the next 60 years. They chose capital. But judges couldn't just blatantly state on the record that they didn't care about dying workers. They had to make this brutal economic choice look like a perfectly logical, objective, legal necessity. So, they took that old, traditional English common law, the one built on fairness and village common sense, and they aggressively bent it to their will. They warped it into an impenetrable shield for corporations, molding a set of 3 ruthless legal rules that were so hostile to the average worker. Later generations of legal scholars would refer to them simply as the unholy trinity of defenses. This trio of legal loopholes was essentially a rigged game of blackjack, where the House, the industrial tycoons, held all the winning cards, and the injured worker never even had a chance to draw. Let us walk through each of these 3 rules one by one, because to truly understand the nightmare of the American factory floor in the late 19th century, you have to see exactly how these legal mechanics worked in practice. The first pillar of this unholy trinity was a concept called contributory negligence. On the surface, the name almost sounds reasonable, but in reality, it was a weapon of absolute devastation. Under this rule, if you sued your employer because a factory roof collapsed and crushed your spine, you had to prove that the company was entirely, 100% at fault. If the battery of corporate lawyers could prove that you were at fault for even a single fraction of a percent in your own accident, you lost everything. You would be thrown out of court without a single dime of compensation. Imagine you are working a heavy timber saw, and the machine lacks any sort of basic safety guard. The blade snaps, flies off the spindle, and severs your arm. It is blatantly, undeniably the company's fault for not installing a 10-cent metal shield. But in the courtroom, the company's attorney would stand up and argue that, on the morning of the accident, you were standing with your feet angled 5 degrees off from the Standard Operating Manual's recommendation. They would argue that this slight misstep contributed to the trajectory of the blade hitting you. The judge would nod, declare you 1% negligent, and dismiss the case. Your severed arm was now entirely your own financial problem. As brutal as that sounds, the second rule might be the one with the darkest, most twisted sense of humor. It was known as the fellow servant rule. The logic behind this rule was a direct, grotesque mutation of the old village common law. It operated like this. Suppose you are working deep in a Pennsylvania coal mine. You are doing everything perfectly. But a fellow miner, standing 30 feet away, is exhausted from a 14-hour shift and accidentally drops his lantern. The open flame hits a pocket of methane gas, causing a massive explosion that leaves you permanently blinded in both eyes. You naturally file a lawsuit against the billion-dollar coal mining syndicate because they refused to spend money installing proper ventilation shafts to clear the gas. What would the courts say? They would rule that your horrific injuries were the direct result of the carelessness of a fellow servant, your co-worker, and not the direct personal action of the wealthy mine owner sitting in a plush office in New York. Therefore, the corporation bore absolutely zero legal responsibility. The judge would then helpfully inform you that you were completely free to sue your co-worker for damages. Yes, you had the profound legal privilege of suing another dying, impoverished coal miner whose only earthly possessions were a pair of rotting boots and a mountain of debt at the company store. It was a brilliant legal fiction that shielded corporate treasuries behind the sheer poverty of their own workforce. And if, by some absolute miracle, you managed to navigate past the traps of contributory negligence and the fellow servant rule, the corporate bosses still held one final, unbeatable trump card up their tailored sleeves: the assumption of risk. This doctrine was the ultimate catch-all. It established that the moment you signed a contract of employment and accepted a wage, you inherently knew about and legally accepted all the dangers that came attached to that specific job. Let's look at a concrete example. In 1890, a railway brakeman named John might lose 3 fingers trying to manually drop an iron coupling pin between 2 moving train cars, a notoriously lethal task that amputated thousands of limbs every year. When John went to court demanding compensation for his lost fingers, the judge would simply look down from the bench and deliver a chillingly pragmatic verdict. The judge would state that everyone in America knew that coupling train cars was a highly dangerous profession. That danger was public knowledge. Therefore, when John accepted his daily wage of $1.50, that meager sum supposedly included a premium or a prepayment for the statistical probability that he would eventually lose a hand. By cashing his paycheck, he had assumed the risk. He had no legal right to complain when the inevitable finally happened. Through these 3 impenetrable legal fortresses, the American judicial system granted corporations a near-absolute license of immunity. It was a system carefully engineered to ensure that the explosive economic growth of the era remained uninterrupted by the pesky, expensive realities of human suffering. The blood, the severed limbs, and the shattered lives of tens of thousands of immigrant workers, the Italians, the Poles, the Irish who poured into the country, were systematically reduced to nothing more than a cheap, expendable fuel source. They were the silent, uncompensated sacrifices required to build the glittering monuments of the Gilded Age. The capital was protected, but the human pressure was building to a breaking point. By the time the calendar turned to the first decade of the 20th century, the United States had transformed into a colossal, unprecedented meat grinder. The statistics from this era are genuinely staggering to comprehend today. Every single year, roughly 35,000 American workers were killed violently on the job. Another 500,000 were severely injured, maimed, or permanently disabled. To put that into perspective, the American industrial machine was wiping out a workforce equivalent to the entire population of a small city every 12 months, all in the name of extracting coal, weaving textiles, and forging steel. The sheer scale of the carnage meant that the working class could no longer suffer in silence. The pressure was boiling over. Early labor organizations, like the Knights of Labor and the fiercely militant United Mine Workers, began organizing massive, often bloody strikes. Their demands were not exactly radical by today's standards. They were asking for something fundamentally basic: employer liability laws. They wanted legislation that would finally dismantle the unholy trinity of legal defenses and force corporations to take financial responsibility when their factories killed or maimed the people working inside them. Under immense political pressure and the looming threat of nationwide labor riots, several state legislatures actually started to buckle. Politicians began passing early versions of these liability laws. The goal was to soften the rigid, cruel legal standards. For instance, some new state laws allowed juries to apply a concept called comparative negligence. This meant that instead of the old extreme 1% rule, where a worker lost everything if they made a tiny mistake, a jury could now decide that the company was 80% at fault, and the worker was 20% at fault, and then divide the financial compensation accordingly. On paper, this looked like a massive victory for the working class. The walls of corporate immunity were finally cracking. But this is exactly where the story takes a fascinating, deeply cynical turn. These early reform efforts failed spectacularly. Why? Because instead of solving the root problem and getting money to starving widows and amputees, these new liability laws accidentally turned human suffering into an incredibly lucrative gold rush for the legal profession. Think about the mechanics of the new system. Even if the law made it slightly easier for you to sue your boss, you still actually had to sue them. You had to hire a lawyer, file a formal lawsuit, and take a multi-million-dollar corporation to court. And the factory owners were not about to just sit back and start writing checks. Their response to these new liability laws was the creation of an entirely new, massive financial sector: the employer liability insurance industry. Rather than paying injured workers directly, factories began purchasing premium insurance policies. When a worker got his leg crushed by a runaway mine cart, the factory owner simply washed his hands of the situation and forwarded the legal complaint to his insurance provider. These insurance syndicates had virtually infinite resources. They deployed highly aggressive teams of private detectives, corporate attorneys, and claims adjusters whose sole purpose was to intimidate, harass, or delay the injured worker until they broke. If you were a paralyzed railroad worker, the insurance company knew you couldn't afford to feed your family, let alone pay a lawyer for a 3-year court battle. They would deliberately drag the litigation out, starving you into submission, until you were so financially desperate that you would accept an outrageously cheap out-of-court settlement. It was not uncommon for a man who lost both of his eyes in a chemical explosion to walk away with a one-time payment of $50 after waiting 2 agonizing years for a check. What emerged was a hostile, violently adversarial, and absurdly wasteful legal bottleneck. It was the worst of all possible worlds. Employers were furious because they were bleeding millions of dollars in insurance premiums and unpredictable jury verdicts. The court system was completely paralyzed, drowning under tens of thousands of complex personal injury lawsuits that took years to resolve. And the workers, the people actually losing their hands, their lungs, and their lives, were receiving only about 30% of the total money moving through the system. The other 70% was being swallowed whole by defense attorneys, insurance executives, and administrative court fees. Nobody was happy. The capitalists hated the financial uncertainty. The workers were literally dying while waiting for justice. Tinkering with the old legal framework had only made the bureaucracy more vicious. It became crystal clear that tweaking the existing laws wasn't enough. The entire system needed to be completely demolished and rebuilt from scratch. But the spark that finally ignited that demolition didn't come from a wealthy industrialist or a powerful politician. It came from a young female journalist and social researcher named Crystal Eastman, armed with nothing but a notepad, a camera, and a relentless obsession with the truth. In 1907, Crystal Eastman, a brilliant graduate of New York University Law School with a razor-sharp sociological mind, stepped off a train and into the thick, soot-choked air of Allegheny County, Pennsylvania. At the time, the Pittsburgh area was the undisputed, ironclad heart of American industry. It was a landscape dominated by the massive steel mills of Andrew Carnegie, where colossal blast furnaces belched black smoke into the sky 24 hours a day, forging the steel that was quite literally building the skyscrapers of the modern world. Eastman arrived in this industrial hellscape with a highly specific mission. She had been hired as part of a massive, unprecedented sociological study known as the Pittsburgh Survey. Her exact assignment was daunting. She was to document, investigate, and analyze every single work-related fatality that occurred in Allegheny County over the course of 12 months, from July 1907 to June 1908. But here is what made Eastman different, and what ultimately made her work so revolutionary. She did not just sit in a comfortable office, reviewing cold, sanitized police reports. She went into the trenches. Eastman walked through the sprawling, impoverished immigrant slums. She knocked on the doors of dark, cramped tenement apartments. She sat at kitchen tables and spoke directly with the grieving widows who were still wearing black, and she looked into the eyes of the young children who would never see their fathers walk through the front door again. When Eastman finally published her findings in 1910 in a groundbreaking book titled Work Accidents and the Law, she completely detonated the hypocritical foundation of American corporate law. For decades, the courts had hidden behind the unholy trinity of defenses, perpetuating the convenient fairy tale that industrial accidents were almost always the result of clumsy, careless, or drunk workers. Armed with an impenetrable fortress of hard data, Eastman proved this was a devastating lie. By meticulously analyzing over 500 fatal accidents, she demonstrated that the vast majority of these deaths were not caused by worker negligence. They were the direct, undeniable result of brutal working conditions. Men were being killed because factory managers relentlessly pushed the speed of the assembly lines to unnatural limits. They died because multi-million-dollar corporations refused to spend a few dollars installing basic safety guards on spinning gears. They died from the sheer, mind-numbing exhaustion that comes from working back-to-back 14-hour shifts in front of open blast furnaces. The most horrifying part of Eastman's report was the financial aftermath. She quantified the exact economic devastation that followed a workplace death. According to her data, in 53% of the cases where a married man was killed on the job, the grieving family received absolutely zero financial compensation from the employer. Nothing. The other 47% might receive a tiny, insulting settlement that barely covered the cost of a cheap pine coffin. The human consequences were catastrophic. Widows were forced to sell off their furniture and take in massive loads of laundry just to buy bread. Even worse, children as young as 8 or 9 years old were routinely pulled out of school and sent to work in the exact same factories and coal mines that had just slaughtered their fathers, simply to keep the family from starving. Through this exhaustive research, Eastman hammered a brand-new philosophical argument into the American consciousness. She argued that industrial accidents were not individual moral failings. They were an inevitable statistical cost of production. A factory owner expected steel gears to wear down and break, and they factored the cost of replacing those gears into the price of their products. They factored in the cost of coal, oil, and transportation. Eastman asked a terrifyingly logical question. If the consumer pays for the worn-out gears and the burned coal, why on earth are widows and orphans being forced to subsidize the cost of destroyed human lives? Her report sent a shockwave through the progressive political establishment. It provided the indisputable empirical ammunition that labor reformers had been begging for. However, sheer logic and statistical data are rarely enough to force a stubborn legal system to change. Sometimes, history requires a visceral, bloody, and terrifying spectacle to finally break the status quo. That horrific catalyst occurred on a Saturday afternoon, March 25, 1911, right in the heart of New York City. The Triangle Shirtwaist Factory occupied the 8th, 9th, and 10th floors of the Ash Building in Manhattan. Inside, hundreds of garment workers, mostly young immigrant women, some as young as 14, were packed shoulder to shoulder, furiously sewing women's blouses amid mountains of highly flammable cotton scraps. When a fire broke out in a scrap bin on the 8th floor, the flames spread with terrifying speed. Panic erupted as the young women abandoned their sewing machines and rushed toward the exit doors and the fire escapes. But when they reached the primary stairwell doors, they found them locked. The factory management had intentionally chained and locked the doors from the outside. Why? Because they wanted to prevent the girls from taking unauthorized bathroom breaks and to ensure no one was stealing tiny scraps of leftover fabric. The fire department arrived quickly, but to the absolute horror of the crowds gathering on the street below, the ladders on the fire engines were only tall enough to reach the 6th floor. They were completely useless. Trapped behind locked doors, with the fire consuming the room behind them, dozens of these young girls were forced to make the most horrifying choice imaginable: burn to death or jump. Thousands of New Yorkers stood paralyzed on the sidewalks, weeping and screaming in sheer terror as they watched young women, their dresses engulfed in flames, leaping from the 9th floor windows. They fell like burning rag dolls, smashing through the firemen's safety nets as if they were made of tissue paper, and slamming into the concrete pavement. 146 workers died that afternoon in a completely preventable tragedy. The public outrage was apocalyptic. But what finally broke the back of the American legal system was the aftermath. When the millionaire owners of the Triangle Factory, Max Blank and Isaac Harris, were eventually put on trial for manslaughter, their expensive defense attorneys utilized the same old legal loopholes, and a jury acquitted them. They walked away completely free. The system had finally been exposed to its absolute rotting core. The public realized that the laws were perfectly engineered to protect capital while legally sanctioning the mass murder of the working class. America could not take it anymore. The tipping point had finally been reached. The visceral horror of the Triangle Shirtwaist fire, combined with the undeniable cold, hard data from Crystal Eastman's Pittsburgh survey, created a political perfect storm. The American public was outraged, and the progressive politicians of the era realized they could no longer look the other way. Tinkering with the edges of employer liability had failed spectacularly. It was time for a structural revolution, and that revolution officially arrived later that same year. In 1911, The state of Wisconsin made history by passing the first comprehensive workers' compensation law to successfully survive constitutional challenges in the state Supreme Court. This legislation introduced a radical new legal framework that we now refer to as the Grand Bargain. The Grand Bargain was exactly what it sounded like, a massive societal compromise. For the worker, the deal offered a profound and immediate safety net. To receive financial compensation and medical care, you no longer had to step foot in a courtroom. You no longer had to prove that your boss was at fault, and you no longer had to defeat the unholy trinity of legal defenses. In fact, even if the accident was entirely your own fault, even if you had been careless, clumsy, or exhausted, the system would still pay your hospital bills and provide a percentage of your lost wages. It became a strict, no-fault system. But there was a catch, and it was a massive one. In exchange for this guaranteed rapid financial support, the worker had to surrender a fundamental right. You permanently gave up the right to sue your employer for negligence. You could no longer take the corporation to court to demand massive financial payouts for pain, suffering, or punitive damages. The days of fighting for a life-altering jury verdict were officially over. Now, you might think the ruthless industrial capitalists of the era would have fought this tooth and nail. But here is the fascinating twist. They actually embraced it. In fact, many major corporate titans actively lobbied for the Grand Bargain. Why? Because capitalists hate nothing more than financial uncertainty. Under the old system, there was always a lingering threat that a sympathetic jury might hand down a massive, devastating financial penalty that could bankrupt a factory. With the new workers' compensation laws, the cost of human limbs and lives was finally quantified, standardized, and made perfectly predictable. Factory owners simply purchased workers' compensation insurance. The bloody toll of industrial labor was transformed from a terrifying legal liability into a neat, predictable line item on a corporate balance sheet. They knew exactly how much their insurance premiums would cost each year, and they simply baked that cost into the final price of the steel they forged or the shirts they sewed. Within a decade of Wisconsin's landmark law, the vast majority of American states had rapidly adopted the exact same model. The modern workers' compensation insurance industry was officially born, and it undoubtedly saved millions of working-class families from the abyss of extreme poverty. However, as we fast-forward out of the smoke-filled factories of the 1910s and step into the 2020s, the dark underbelly of this grand compromise has slowly revealed itself. The system that was explicitly designed to protect the working class from predatory lawyers has mutated into a sprawling, hyper-bureaucratic, multi-billion-dollar machine. Today, the American workplace still extracts a heavy physical toll. According to modern estimates, over 2 million American workers suffer from severe injuries or illnesses on the job every single year. But the nature of the battlefield has fundamentally shifted. If you injure your spine working in a massive Amazon fulfillment center today, you are not facing off against a cartoonishly evil baron who locks the fire escape doors. Instead, you are forced into the ring with a faceless monolithic insurance corporation that uses highly complex algorithms to evaluate the financial worth of your chronic pain. When that modern warehouse worker files a claim because they blew out a spinal disc after lifting 10,000 cardboard boxes over a period of 5 years, they are met with an immediate automated wall of resistance. The insurance companies employ vast networks of independent medical examiners, doctors who are technically independent, but whose paychecks rely heavily on the insurance industry. These examiners are incredibly skilled at looking at an MRI and legally declaring that your shattered back is actually just a pre-existing degenerative condition completely unrelated to your warehouse job. Modern workers quickly realize that they have simply traded one brutal battlefield for another. Instead of arguing about contributory negligence in front of a robed judge, they are now fighting a grinding, exhausting war of attrition against towering stacks of medical paperwork and automated denial letters. They have to deal with corporate claims adjusters whose entire job description is to minimize payouts. And they are sometimes even tracked by private investigators, hiding in grocery store parking lots with telephoto lenses, desperately hoping to catch the injured worker walking without a limp for a few seconds to terminate their benefits. The violent, immediate bloodshed of 1905 has largely been scrubbed from the factory floor. But it has been replaced by a slow, agonizing, bureaucratic bleed. The system protects the worker from starvation, yes, but it forces them to beg, jump through hoops, and prove their suffering over and over again to a spreadsheet. And as we look toward the shifting future of labor, it forces us to ask if the grand bargain is slowly unraveling altogether. When we look back at the long journey from that helpless worker caught in the stamping machine in 1905 to the sprawling insurance labyrinth of today, we are forced to confront a deeply uncomfortable truth about how our society operates. The industrial factory did not merely manufacture steel beams or cotton shirts. It actively manufactured how we calculate the exact monetary value of human life. In the 19th century, the American legal system functioned as a razor-sharp mechanical gear, violently cutting down anyone without wealth or political power. Today, we have essentially wrapped a thick rubber bumper around that exact same gear. We call that rubber bumper workers' compensation. You might not physically bleed to death on the factory floor anymore, but you can absolutely bleed out financially and mentally while waiting months for a stranger in an office cubicle to decide exactly how many dollars your shattered knee is worth. The grand bargain of 1911 was, at its core, a survival mechanism. It prevented industrial capitalism from collapsing under the weight of its own ruthless brutality. But the wheel of history has a funny way of turning right back to where it started. Just look around at the modern gig economy. Look at the millions of people driving for Uber, delivering food for DoorDash, or dropping off packages as gig workers. These workers are legally classified as independent contractors. And because of that specific legal label, they are entirely locked out of the workers' compensation system. If a gig driver is severely injured in a car crash while rushing to deliver a hot meal on time, the tech company they drive for is completely off the hook. There is no guaranteed medical coverage. There is no disability paycheck. The driver is left to shoulder the entire financial and physical burden alone, exactly as they would have a century ago. It really makes you stop and wonder. Are we currently using the shiny, futuristic veneer of smartphone apps and algorithmic management to quietly recreate the exact same unforgiving labor environment of 1905? When the legal protections we fought a century to build are erased by a simple terms of service agreement, who is truly paying the ultimate price for the convenience we consume every single day? If you are still sitting here listening to these final words, I hope this video has given you a completely different perspective on a basic right we take for granted every single day. The safety, the medical care, and the financial security you enjoy at your workplace today were quite literally built on the blood and shattered bones of tens of thousands of workers who came before us. It is a history worth remembering and a protection worth defending. If you found this journey valuable, please hit that like button and subscribe to the channel. We will continue to peel back the hidden, sometimes uncomfortable layers of our past in upcoming videos. Thank you so much for watching, and I will see you in the next one.